Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. Good morning. We are here for oral argument in CV22 0761, Preston et al. V. Sendas Community Association. These proceedings are being video and audio recorded and live streamed. So counsel, we ask yourself to please identify you and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock if you'd like to reserve a portion of that time for rebuttal. Also, please keep in mind that we've read the briefs and have conferenced the case this morning. And with that, counsel, you may proceed.
Good morning, Your Honors. May it please the Court. My name is Brian Locker, and I represent the appellants, a group of homeowners in the Sendas Association of Homeowners. The rights one has to utilize their real property in the way that they deem appropriate is fundamental in Arizona. That is why covenants and restrictions, CC&Rs, are one of those special contracts that is subject to additional judicial scrutiny to ensure that additional covenants are both reasonable and foreseeable. Restrictive covenants are to be strictly construed against the person seeking to enforce them, and any ambiguities or doubts as to their effect should be resolved in favor of the free use and enjoyment of the property and against restrictions. The amendment at issue in this case runs afoul of Callaway because a person reviewing the CC&Rs could not have reasonably foreseen the dramatic expansion of the regulation of leasing imposed by the amendment. In this case, the original CC&Rs expressly permitted leases. They placed no restrictions on how long those leases should last or how they may be advertised. Accordingly, the amendment was entirely new in character and therefore unforeseeable.
Counsel, let me ask you, your focus is foreseeability as opposed to reasonableness. Is that fair?
Your Honor, I would say that it fails on both respects.
So you're arguing that this restriction, prohibiting leases of less than 31 days is unreasonable?
Given the notice that was provided by the original
CC&R. The question is, just in general, is a restriction of 31 days unreasonable?
Under the circumstances, Your Honor, we would say that yes, it is unreasonable.
So let me ask, there was an amendment in 2009 that sort of put boundaries on the length of leases, correct?
There was not an amendment to the original CC&Rs, Your Honor. There was a rule that was adopted as part of the bylaws, which is fundamentally different than what was done more recently, which is...
That's true, but is that a difference with a distinction or not?
Absolutely, Your Honor.
So if the HOA board had put in 31-day rule, you wouldn't be here, you wouldn't have challenged that?
If they adopted a new rule, Your Honor, we wouldn't be here?
No, that's my question.
Right. No, well, we wouldn't be here under the same legal issue, but we certainly would be challenging that rule because...
And that doesn't surprise me, so I'm trying to figure out why that's so fundamentally different than what brings us here.
Sure. So the difference between an adoption of a rule under the bylaws and an actual amendment of the CC&Rs is that the actual restriction on leasing through bylaws was abrogated by statute. So Arizona passed a statute that required leasing restrictions to be adopted in the declaration. And
so to the extent, though, that you're focusing on foreseeability, and I understand you're arguing both unreasonableness and lack of foreseeability, how is the 31-day, given this action in 2009, how is that unforeseeable? Because that put a temporal limitation on leases kind of a long time ago.
Sure. So if you look at what Callaway specifically requires, it requires that you look to the declaration. And so regardless of whether there was a prior rule that likely predated even the withdrawing of that bylaw probably predated many of the purchases of the plaintiffs here in this case, right? So that bylaw probably was not even in place when many of these people purchased their home. But regardless, under Callaway, the test is you have to look at the declaration. Whether a bylaw existed at some point in the past is irrelevant under the appropriate test.
So if that's the standard, you could have a circumstance where for 50 years, 31-day or less leases were prohibited by rule or regulation, and your argument would be if then there was an effort to change the CC&Rs, that was not foreseeable. Is that your point?
Under Callaway, that would be the result, Your Honor.
Well, I want to understand your argument.
Sure, absolutely. Again, we have to apply the rule in Callaway. And Callaway specifically requires that for the inquiry of foreseeability and reasonableness, you have to look at what's in the declaration. Anything else wouldn't be noticed.
But if I hear you right, you're saying the declaration, but only the declaration. All these other things you can't even consider. Is that your point?
Correct. There's something very important about and what the legislature did when they adopted the statute regulating short-term rentals and requiring that the rental regulation be adopted into the declaration is that the declaration is the contract, right?
And let me, you'd mentioned one final thing, and then I'll be quiet for a while. You had mentioned the timing of when plaintiffs purchased their units. Do we know that from the record? Where's the indication in the record when they purchased their unit?
We don't, and I brought it up simply as an example. It doesn't weigh into the analysis in this case. But no, it's not on the record, to be clear.
Thank you.
Yep.
Didn't the CC&R specifically give the board the discretion to determine what is a nuisance?
So, yes and no. So let me explain. The provision that you're referring to specifically, the nuisance provision, and I'll just pull the site so I can be accurate here. So you're referring to section 3.4. In 3.4, it talks about specifically not just a nuisance, but nuisance as it relates to construction activities. And so
I thought it referred to business activity.
So I'll state exactly what it says. It says, nuisances, construction activities, no rubbish or debris of any kind shall be placed or permitted to accumulate upon the adjacent, upon or adjacent to any lot or parcel, and no odors or loud noises shall be permitted.
How about 312?
So 312, obviously dealing with the residential use, right? And 312 goes on to define exactly what is a business activity, right? And I think the really important thing to look at there is the very last sentence, right, of 312, the leasing of a residential unit by the owner thereof shall not be considered a trade or business within the meaning of this section. And so, again, looking at foreseeability and reasonableness, someone reviewing these CC&Rs and saying, okay, what residential use, what do we got here? Leasing is not a commercial activity. I should be okay. That is contrary to the argument made by the appellees, right, who want to have this court characterize the idea of short-term rentals at all to be akin to a hotel or something of that kind.
There's not much difference between the two, is there?
There are fundamental differences between a hotel.
If I'm renting a unit in a condominium complex, or in this case a house for 2 or 3 days versus Hilton down the street, I don't see much difference between the two. Are they taxed the same?
So they are both taxed by the municipality, certainly, but
well, the tax code would view them as the same.
I don't know that they would.
You're offering it for short-term rent. You're offering it for short-term rent.
Yeah. So the idea of the taxation obviously isn't in the record, and I'm certainly not a tax expert. But what I will say is there are major distinctions between a hotel and a short-term rental, because in a hotel you have actual individual rooms that are being rented out on daily basis. You have
weekly hotels that rent by the week.
Sure, but these are done in commercial establishments, and in this case, again, going back to what the actual CCNR state, is that the leasing of a residential unit is not a business activity, and even in the CCNRs where it talks about transient and use as a hotel, that is in the context of the condominium uses, right, which is differentiated in the CCNRs between single-family residents and cordoned off, right? So they don't mention transient use when they're talking about residential use. They only talk about it in the context of the condominium use, which kind of makes sense, right? Because in condominium uses, you have units all kind of clustered together. So there could be more problems in a condominium use where you have more transiency, because if people are constantly moving in and out of condominiums, you've got people below you, potentially people above you, and that kind of transient use is more disruptive than it might be in a single-family residence.
But that's a factual distinction that isn't really before us, isn't it?
No, and Your Honor, to be clear, I don't think that you need to make that factual distinction to apply Callaway in this case. So, Your Honors, we believe strongly that our position in this case is made effectively in our briefs. I'm here to answer your questions. In the absence of any, I'm going to just highlight a few things that I think that I'd like to draw your attention to as you evaluate the merits of this appeal. The first being the actual rulings from the lower court, because I think that it's instructive for the purposes of this appeal. So, first and foremost, the lower court held in this case that I have to follow Callaway, is the quote. And so the court understood correctly that Callaway was the appropriate case to apply here. However, what he then goes on to explain on the record is that Callaway permits an amendment to fill a gap in the existing CCNRs. The gap here is what to do about short-term occupancy. He then goes on to say that I think the terms of 3.12 by themselves, residential use by a single family, and the most natural reading of that is that people who live there, either as owners or tenants, means permanent or semi-permanent or long-term residents, not a short-term residence. I think various provisions that restrict commercial use or business restrictions, I think those are additional harbingers, provisions that give notice. Those are the reasons for my decision. I call your attention to that specific, those specific parts of his ruling, because we believe very strongly that the court misapplied Callaway on those particular issues. First, there was no gap here. The trial court believed that the gap was created by this idea of short-term occupancy. But the reality is that short-term rentals are not an advent of 2019, 2020, or 2010, or at any time. People have rented their properties for any lengths of time for as long as rentals have been a thing. Certainly the advent of VRBO and Airbnb have proliferated it, but this was not a new invention. This is something that has existed. And so, and 3.12 in particular, which is what the trial court honed in on, is not ambiguous. It is clear. It specifically carves out leases as an exception to the business use.
Counsel, let me, speaking of 3.12, I'm wondering if you can help connect a couple of sections within the CCNRs for me. So 3.12 begins with all residential units shall be used, improved, devoted exclusively to residential use by a single family. And then there's some, no trade or business, but there's some exceptions. But that first portion of 3.12, in comparison to 1.49, I think it is, 1.48 talks about a residential unit, 1.49 talks about a single family. Is there some connection? Does 1.49 help us with 3.12?
So 1.49 specifically defines single family, right? So it says a group of one or more persons, each related to the other by blood, marriage, or legal adoption, or a group of not more than 3 persons, not also related, who maintain a common household in a residential unit. So yes, 1.49 is instructive for 3.12 in the sense that it provides additional help on what a single family is. But residential use itself is not specifically defined, and importantly, it was not redefined in the amendment, right? So while the appellees argue that, oh, well, we're filling a gap created by this whole idea of residential use, well, not really, because they could have attempted to define residential
So
use,
how,
but they
how
didn't.
should we interpret residential use?
So, Your Honor, it's difficult because there aren't a lot of cases in Arizona that are instructive, and so you'll see in the briefs, obviously, that we recommend looking at jurisdictions that have reviewed this on point, and so specifically in Montana, Colorado, Washington, where they've applied tests very similar to Callaway and have actually had residential use that was on point. So in particular, Washington, and we do an analysis in the reply brief on the Wilkinson case, they hold that if a vacation renter uses a home for the purposes of eating, sleeping, and other residential purposes, this use is residential.
Is there a time component on that in that case?
Well, that was the issue in the Wilkinson case, was similar to this case, an adoption of a durational restriction on leasing, and the court in that case specifically struck it down because they applied a test very similar to Callaway, obviously not identical, but very similar, looking at reasonableness and foreseeability. And they find, and also I would say that, Black's Law Dictionary, and obviously the parties have done sort of a battle of the dictionaries in their briefing, talking about whether a durational component is inherent in the idea of residential use. And one thing that I would call to your attention, Your Honors, is the Colorado case that we cite, because they do a roundup in that case and a survey of jurisdictions and whether a durational component is inherent in residential use. And what they determine is the majority opinion is no. There is not a durational component inherent in residential use. And so the law cited by the appellees in this case is the minority view. And so we would and there's nothing in Arizona that would suggest that they've adopted one or the other, and we recommend, obviously, we support the adoption of the majority view. I see I have about 3 minutes. I'd like to reserve.
Thank you.
Thank you.
Counsel.
Good morning, Your Honors. May it please the Court. Curtis Eckmark on behalf of Las Sendas. It would be manifestly unjust to allow plaintiffs to veto the vote of 2,614 owners who voted to preserve the residential character of their community. Every purchaser at Las Sendas had a right to rely upon the original restrictions that required every property, leased or not, to be occupied by a single family who is using that property, quote, as their residence. That concept is reiterated over 100 times in the original declaration, and this amendment does nothing more than explain when a rental qualifies as a single-family residence under the declaration. Plaintiffs cannot meet their burden of showing that the trial court abused its discretion when it denied their request for a TRO, especially in light of the fact that this court denied the same request 4 months ago. One thing that we have not talked about is that the association's derivative standing defense was set forth in our amended answer, and plaintiffs in their reply brief try to distinguish between their individual claims for damages and the general claim that the amendment is invalid. However, the only thing on appeal right now is count 9. That's it. And that is the count for injunctive relief. And that count applies equally to each and every owner. Either the amendment's valid or it's not. And as explained in the Connect case that we cited, That is a classic derivative claim that requires compliance with the derivative statute. Plaintiff mentioned ARS 1806, and that statute specifically...
Counsel, before you go there, on the derivative claim argument, what was the trial court's ruling on that?
We did not include that in the motion for summary judgment, but we did file a motion to amend our answer to include that as a defense. Plaintiffs did not contest it. The court granted it, and we filed an amended answer, so we have not waived it.
Well, and I get that it's joined in the pleadings, but we typically review what was argued in front of a superior court in motion practice or at a jury, and it strikes me that the derivative claim was not.
You are correct, Your Honor, but it is another basis to uphold the trial court's ruling.
Would that, though, if we engaged in that, wouldn't that be a remand for the trial court to make a determination on that point in the first instance?
I think you have everything on the record you need to make that decision, but that's obviously an option. With respect to 33-1806.01, that statute requires that every member of a planned community shall use their property, quote, in accordance with the declaration's rental time period restrictions. And the definition of declaration in that statute includes both the original instrument and, quote, any amendments. Therefore, plaintiffs had a statutory duty to use their property in accordance with any rental time period restriction in an amendment. That is a statutory pronouncement that rental time period restrictions are valid regardless of whether they're in the original instrument or whether they're in any amendment. And any attempt to add any additional test would both violate the statute and render the statute meaningless.
How do we account then for Calway? Because it strikes me that Calway really does kind of change the engagement.
It's a great question, Your Honor. First, Calway mentioned 1817, not 1806.01. Second, for reasons that I will never understand, the lawyer in Calway for the association conceded and stipulated that 1817 or Dreamland applies and 1817 does not. Therefore, that statement is dicta, and I am certainly not making that concession either with respect to 1817 or 1806.01. And if you think about it, associations don't need any statutory authority to enforce our declarations. That we don't need that from the legislature. We have that because it's a contract. So what then would be the purpose of this statute? There is no other purpose of this statute other than to say 1806.01 says that rental time period amendments are valid, period. We know that the legislature knows how to supersede CC&Rs and add additional requirements because they did so 26 times in the Planned Community Act. We know the legislature knows how to require unanimous consent for amendments because they did it in the Condominium Act. But they made a specific decision in 1806.01 to say that rental time period restriction amendments are valid, period. You had mentioned also, Your Honor, the rule, and that's really important for four reasons. The first is that Section 5.3 in the CC&Rs, remember this rule stems from the CC&Rs. Section 5.3 specifically warned every purchaser since day one that the board could adopt new restrictions on the uses of lots. And that's important because that provision standing alone authorizes the restriction in this case. Second, it is a very strong warning, even stronger than the one in Nickdon, sufficient to pass any type of Calway test. And third, because the association actually passed a rule in 2009 banning rentals less than 6 months, it is impossible for a plaintiff today to claim that the association imposing a time restriction is unforeseeable because we've been doing it for 14 years. And also because the amendment was actually less restrictive than the rule it replaced, the plaintiffs now have more rights to rent than they did before, which is exactly the opposite of a Calway situation. And speaking of Calway, when we get to the original restrictions in this case, even if you set aside 5.3, it is really important. Opposing counsel mentioned 3.12. First, vacation rentals involve contracts and licenses, not leases. Second, the right to lease was never unregulated. The first regulation is that the lease needs to be, quote, by the owner thereof, not a third party like Airbnb. The second regulation is that the sentence doesn't say leasing is allowed. It doesn't say all leases, any leases, leases. It says the leasing of a residential unit, capital R, capital U. And that triggers two more restrictions. As Your Honor mentioned, the first sentence of 3.12 requires that residential units be occupied by a single family. 1.49 says the only way you qualify as a single family is if you are either related or not more than 3 unrelated people who are maintaining a common household. Also, 1.48 requires
What does that mean, to maintain a common household?
It certainly doesn't mean staying for a weekend, Your Honor. What we have said, what we have defined in this case, is it means you have to be there at least a month. And that's part of what we've done in this case, is we've explained what that term means. Also, it's important to say that 1.48 requires that residential units be used, quote, as a residence, not for residential type uses like some of the cases that opposing counsel cites from Colorado. This one, if you look at the declaration carefully, says they must be used, quote, as a residence. So from day one in this particular community, every lease had to be used as a residence.
For use as occupancy as a residence?
Yes, as a residence. And by either people who are related or by 3 or less unrelated people maintaining a common household. So also, there were other restrictions on the regulation of leasing as well. For example, the owner had to give up the right to use the amenities. The owner had to get board approval before they could apply for a rental permit with the city of Mesa. The Architectural Review Committee could declare a lease to be a nuisance, Your Honor. And by the way, when you look at 3.4, it's not limited to construction activities. It says any activity or other activities. Also, there's another nuisance provision built right into 3.12 where it says that the board in its sole and absolute discretion has the ability to decide if any activity is not consistent with the residential character of the community. So again, from day one, every property, leased or not, had to be used as a residence by a single family. Now going to Callaway, we know what the test is not. The test is not whether the language already existed, because if that were the test, no amendment would ever pass, right? We also know that Callaway told us, quote, the restriction itself does not have to necessarily give notice of the particular details of a future amendment. So in this case, the original declaration does not have to say, someday we could add a temporal component to the definition of residence. Callaway tells us that would rarely happen, and therefore that's not the test. What does Callaway allow? Callaway allows refinements. And in this case, the amendment is a refinement because it sets forth the line. It tells everybody exactly how many days a rental must be in order to be considered a residence. Callaway allows you to correct any errors. And to the extent the original drafter erred by not including a definition of the term residence, this amendment solves that problem. Callaway allows us to fill in gaps. And in this case, there was a gap because the original restrictions drafted in 1995 were done at a time before the modern-day tech industry of vacation rentals even existed. And so what this amendment does is tell us how the original restrictions apply to a new industry. And even if this
Counsel,
court...
Your argument isn't really that this is to correct an error.
It sure would have been nice if they would have defined residence. It would have avoided all this drama.
There are many things in hindsight, though.
Yeah.
That, I mean, it is fair that perhaps the change in how short-term rentals occur wasn't contemplated back then. I mean, I just want to make sure I understand your argument.
You're correct, Your Honor. I'm not saying it was a scrivener's error. Correct. But even if this court characterizes the amendment as a change in a restriction, Callaway even allows that. And this is really important. We know that Callaway allows definitions of previously undefined terms because the Callaway court stated, quote, although garage was not defined in the original declaration, we find its inclusion permissible because the original declaration referenced a garage. Thus, a later amendment defining the term was reasonably foreseeable, period, end quote. In this case, Callaway allows the definition of single-family residence because that concept is mentioned 121 times in the original declaration. We also know that Callaway does not have a problem if the way you amend it imposes additional obligations. Why do we know that? Look at what they allowed. They allowed an amendment that defined a term garage in such a way that there were two restrictions. You couldn't live in it and you had to use it for storage. Callaway also allowed a definition that contained a residential use restriction. So we know that's not the test. Callaway allows the imposition of additional restrictions through amendments. What they don't allow is if the amendment is, quote, entirely new and different in character, untethered to the original covenant. But in this case, the amendment is tethered to multiple sets of restrictions, any one of which is sufficient. First, it's tethered to and consistent with the original land use classifications, which warned that certain uses could be regulated and were limited to certain areas. Second, it's tethered to and consistent with the single family restriction because it regulates an activity in vacation rentals that is not limited to single families, as that term is defined in the CC&Rs. It's also tethered to the requirement that the property be used as a residence because it explains when a rental is being used as a residence. And to your point earlier, Your Honor, it's also tethered to the three business use prohibitions set forth in 312. 312 says you cannot use the property in any way that is detectable by the neighbors, involves people coming or going to the unit, or is inconsistent with the residential character as determined in the sole discretion of the board. Long-term leases, consistent with all of those. Nightly rentals, consistent with none of those. And when we talk about foreseeability, Your Honor, it's really important to keep in mind that there can be multiple foreseeable outcomes in any given situation. If I see some guy who's drunk walking across the street, he could get hit, but maybe he doesn't. The point is, it's the same when we're defining a term in a declaration. There's not just one foreseeable outcome. There can be multiple foreseeable definitions. And with all due respect, I totally disagree with the way they're defining residence. They say there's no temporal component at all, which would allow a place to be rented out by an hour and still be classified as a residence. They're using the Colorado, Washington, the Arizona statute that talks about cities. All those things define residential uses. They don't define what it means to be used as a residence. For example, I slept and ate on an airplane last week. That's not my residence. You can eat and sleep in a hotel. That's not a single family residence. Eating, sleeping, things like that, they may be residential uses, but they don't go far enough to make something a residence. That includes a temporal or a timing or a permanency component. And even if this court totally disagrees with me and says, we like his way better, that's my point. There can be multiple ways. This isn't a zero-sum game. You would still have to analyze this amendment independently. And the only way that you could rule that this amendment is not foreseeable is if you ignored the fact that, one, Callaway said that defining previously undefined terms is foreseeable. Number two, you ignored the fact that 2,614 people and the trial judge thought it was foreseeable. Three, you'd have to ignore the rule that's been in place since 2009. Four, you'd have to ignore the common usage of the word residence. You can ask 1,000 people where they reside. Not one of them will give you the address of the Airbnb they stayed at last weekend, because you have to leave your residence in order to go on vacation. You'd have to ignore the dictionary definitions in Webster's and Black's 11th edition, because they both define residence with a temporal component, a place you stay at for a certain period of time, as opposed to just a temporary sojourn like a vacation rental. You'd have to ignore the case law that we've cited, saying that there are both time and permanency components to the term residence. You'd have to ignore the fact that the government doesn't allow you to claim that the Airbnb you stayed at for a weekend is your residence. Also, Arizona specifically defines transient and hotel use as less than 1 month, which is exactly what the amendment does in this case. Also, Section 1.44 in this case banned hotel and transient use, even in the apartment area when there was clearly leasing going on. That would make it absurd for an owner to think that they could do transient or hotel leasing in the single-family residential section. Also, you'd have to ignore the warning in 312 that the board could determine what is a nuisance. You'd have to ignore the single-family restriction because it is much more likely for someone who's not a single family to be there for less than 30 days than more than 30 days. Also, 3.16 warned everyone that the board could deny their application for a rental permit. 3.4 warned about nuisances. If you ignored all of those things, with all due respect, you'd be doing something much worse than just striking down an amendment. What you would be doing is stripping away the valuable residential single-family protections that all of these people were entitled to rely upon. In other words, you'd be allowing plaintiff to use Callway as a sword rather than a shield, and that's not the purpose of Callway. If we want to talk about foreseeability, the only thing that was not foreseeable to the people who reside there is that the house next to them could be someday used every weekend by strangers for parties and vacations. That's definitely not foreseeable in this case. And so, I forgot, there's also a disclaimer of implied covenants with respect to this case. The Washington case that they mentioned that they cited in the Court of Appeals, the Wilkinson case, they didn't mention that the Idaho Supreme Court in Adams specifically rejected that case and decided to follow the 11 cases that I've cited that specifically allow rental restriction amendments. Also, Washington has subsequently passed a version of the Planned Community Act that says, ironically, if you follow the statute, the amendment is valid. And there's a new case that came out afterwards called Belanco that says if you follow the statute, the rental restriction amendment is valid. They cited the Mogollon case, but in that case, it obviously didn't involve rental restriction. What it involved was something completely different. In that case, they did two things. They created a new restriction, and then they defined it with a temporal term. In our case, the restriction was already there. The restriction was you had to use it as a single-family residential property. The rule was already there. All we did was actually make the restriction less restrictive by replacing the rule with the amendment, Your Honor. Any other questions? All right. Well, thank you very much.
Thank you, counsel. All right, counsel, a little less than 3 minutes for rebuttal.
Thank you, Your Honors. Just a couple of points. One, opposing counsel listed off a litany of things that would be problematic and in contrast to or in violation of the residential use restriction in the CC&Rs. Things like detectable by the neighbors, people coming and going from the property, things of that nature. Well, I just want to draw Your Honors to the fact that that would apply equally to someone who leases their property for 31 days as opposed to 30, which in the former case would be allowed and the latter would be prohibited. So it doesn't seem to apply there. Opposing counsel glossed over ARS 9-500.39, but I think it's instructive here. The short-term rental regulations that were passed by the legislature that specifically state in the definition of vacation rental and short-term rental that it does not include a unit that is used for any non-residential use. So we have the legislature in Arizona specifically applying or drafting and passing a law related to short-term rental and excluding it from definitionally from non-residential use. Therefore, the legislature treats vacation rental and short-term rentals as residential in nature. Just briefly, Your Honor, the derivative action and issues raised in the answer brief are not before the court. The trial court didn't even know about them when the argument took place, and so it's not before us. Another thing, opposing counsel mentioned that the only count on appeal is count 9. That's inaccurate. Counts 1, 3, and 9 were all denied as part of the summary judgment, and the scrutiny to be applied here is de novo because the court applied the law as the sole reasoning behind its ruling, and the construction of contracts and the application of law are all reviewed de novo. Thank you, Your Honors.
Thank you. Council, we thank you both for your written briefs and your arguments today. You've given us much to think about. We'll take the matter under advisement and issue a ruling in due course, and we are adjourned.